This is, I believe it's from yesterday. I think it's from yesterday when attorney for U.S. Department of Trustee, the United States Trustee, Jennifer Jaimo, probably made a final blow to the Owens family. Well, this scam, their bankruptcy scam, as a result of their GoFundMe scam, and probably a lot more that we don't know yet. Welcome to the show.
Santa Claus, riding in with the winter laws. Santa Claus, streaming live for the roaring masses. Ho, 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 raise them horns, old Judge King in a crown of thorns. Santa Claus, streaming live for the roaring masses. Santa Claus, Santa Claus, Santa Claus, Santa Claus.
Yeah, as if you follow the story, then you know what's about to happen. If you're completely new to this story, it is Ron and Jan Owens, the parents of serial pregnancy scammer Laura Owens, who for the past decade, 12 years, has at least 4, probably 5, maybe even more, victims of her, oh, you don't want me? All of a sudden I'm pregnant, and it's twins, and you gotta pay, or you have to date me and I will get rid of them. Or it's insanity. And now Laura Owens is facing trial in Arizona with 14 counts, 14 felony counts of perjury, identity theft, tampering with evidence, and stuff like that. As an example, she stole the story from a woman who was carrying twins but lost one of them. She stole that story, and she stole that woman's sonogram or ultrasound and presented it as her own, just to get an advantage against Clayton Eckert, the former bachelor. It is absolutely despicable. Now, her parents has funded her lifestyle all her life. Ron Owens is, or was, an extremely famous radio host back in the day. Made him a multi-millionaire. And now it's all gone. Because his wife, Jan, more or less leached it all away. Jan and Laura leached it all away. And now Ron Owens is past 80 with Parkinson's, about to lose his house. Now, before you think, oh, poor thing, where is his GoFundMe? Don't. Ron and Jan Owens has a combined pension and social security of over $21,000 per month. And they still can't make ends meet. They made a GoFundMe. The GoFundMe raised over $132,000. That's all gone. Out of those $132,000, which was presented as, please help Ron, he has medical needs. Out of $132,000, $243 went to Ron's medical needs. The rest went to Laura Owens. It went to an $18,000 credit card debt at Macy's, among other things. Now, last year, they filed for bankruptcy. It didn't work out so fine, so they got it dismissed. Chapter 13 bankruptcy last year. But then they stopped paying the mortgage. And they thought, well, let's file a Chapter 11 bankruptcy to stop the foreclosure and auction of the house, which, well, sort of succeeded. The house would have been auctioned off, I believe, in May or something of the sort. You guys, I believe it is May. But so they got an extra, up until now, 3 months. But during that time, they have not paid mortgage or anything. Their debt has risen. Let's just say their home is valued at around $1.5 to $1.7 million. Yeah. It's a decent house. They owe more than $2.1 million. Imagine that. They have a combined pension and social security of $238,000 a year. And they can't make ends meet because Jan and Laura Owens leeches their father, leeches Ron dry. And to my understanding, he happily lets them. Don't know much about happily, but he lets them. And he keeps defending his daughter and everything. So yeah, it's an absolute fustercluck. But now, after many tours, after many papers, after a lot of lies from Jan Owens to the bankruptcy court, the United States trustee, Jan Jaimo, now put her foot down in this response to the Owens attempt to dismiss this bankruptcy case. Oh, look at that. Thank you so much. Gold coin. Thank you so much, David. 10 euros. 10 euros. Thank you, thank you, thank you. Yeah, you who are watching on mobile, you can support this channel via euros. Which is something... I barely know how it functions, but I appreciate every single one of them. Every single one of them. Other ways to support, because, yeah, you know, PayPal, buy me a coffee, super chats, gifted memberships. You know all the YouTube things. Always appreciated, never ever necessary. If you're choosing between bread and me, choose bread. If you're having a hard financial time, I forbid you to financially support this channel, okay? Now, if you are the type of person who are buying 3 cups of coffee on Starbucks, yeah, hand it over. Jokes aside, always appreciated, never ever necessary. All right, let's get to it. In the United States Bankruptcy Court for the District of Arizona, in response, Elizabeth Ann Naylor and Ronald Stephen Owens, debtors. The United States trustee, UST, you know, when a government entity has, let's just say, lack of humor or lack of prestige, is when their abbreviation doesn't actually say anything. I mean, Ust. It's not like Operation Shield or something like that. No, Ust. Oh, thank you, Heidel. Sent 2 euros. Thank you so much. Much appreciated. Much appreciated. Oh, here we go. Thank you so much to T2 for $20, my Starbucks money. Thank you. Thank you so much. Thank you. I deeply appreciate it. All right, folks. Let's go. Ust, by and through undersigned counsel, files this supplemental response to the motion to dismiss case docket 57, filed by debtors Anne and Ron Owens, and respectfully submits the following memorandum of points and authorities. Folks, this is going to get spicy. And I'm going to get snarky. Debtors filed their voluntary bankruptcy petition under Chapter 11 of the United States Bankruptcy Code. See Docket 1. Debtors previously filed a voluntary bankruptcy petition in this court under Chapter 13 on the Code on August 14th, 2025. Hereinafter, Chapter 13. The Chapter 13 was dismissed on January 26th based on debtors' failure to comply with the recommendations of the Chapter 13 trustee with respect to the debtors' Chapter 13 plan. Yeah, they were told to pay your fucking debts, produce documents. They did nothing. Debtors filed this case on May 22nd of this year, less than 4 months after the Chapter 13 was dismissed. On June 8th, the debtors filed their emergency motion to continue the Section 362A stay, to which the UST objected. The UST incorporates the UST's objection to the motion to continue to stay. A stay here means, please don't make us do it. As it fully set forth herein, the final hearing. Herring is something completely. Herring is a very, very nice fish when pickled. Oh, thank you so Parabellum sent 5 memberships. Thank you so much. It went to Silhouette, Kim Schultz, Dog Life, through Truth Always Wins, and Oregon Grandma. Thank you. Much appreciated. A final hearing, not herring. Herring is only good for pickled herring. Oh, amazing. Yes, I'm Swedish. It's a Scandinavian thing, I know, but I trust me, it's actually nice. Once your taste buds is used to it. Hearing on the debtor's motion to continue stay was held on July 1st, at which time the court denied the debtor's motion. On June 24th, debtors filed their motion to dismiss case. Yeah, they were caught lying to the court, and they tried to get away with it by trying to voluntarily dismiss the bankruptcy case, and no. The UST filed a limited objection to that motion, requesting that the case be dismissed with prejudice and a 1-year bar to refiling. Oh, Jan, you should have taken that offer. You should have taken that offer. Pickled herring. Tasty food or crime against humanity? The debate continues. Nope, it's not a debate. It's a debate when it comes to fermented herring, as in surströmming. At the July 1st hearing, the court withheld ruling on the motion to dismiss and directed the debtors to produce certain documents, including an accountant of a certain GoFundMe funds received by the debtors pre-petition. Yeah, they tried to hide that from the bankruptcy court. It didn't work. Thereafter, the debtors produced documents and appeared for examination under oath at the meeting of creditors pursuant to Code Section 341A on July 16th, We listened to that a while back, and it was amazing. Absolutely amazing. Oh. And Parabellum celebrates 32 months as a member. Wow. No to Starbucks, yes to memberships. Yay! That has also amended several schedules and the statement of financial affairs. The court will consider dismissal at the continued hearing set for August 6. That is Thursday. The UST now files the supplemental response to the motion to dismiss, requesting that the case be dismissed with prejudice with a 2-year bar to refile in bankruptcy in any federal bankruptcy court. See? Up here. Up here. Dismissed with prejudice and a 1-year bar to refiling. And after they produced more documents, that Miss Jamo changed her mind to no prejudice with 2-year bar to refile in bankruptcy in any bankruptcy court. Here, that's how you know you've fucked up. Oh look, Mr. Jingles. Hello. Mr. Jingles really likes his strawberry hut. Look at him. Look. Oh, only cats moment. So, instead of Mr. Jingles just being on his platform, now I framed his self-cleaning. Oh. All right. All right. Introduction. In advance of the August 6th hearing, the question that UST has evaluated is whether creditors are better served by conversion to Chapter 7 or by dismissal with a 2-year bar to refiling. The UST has concluded that dismissal with a 2-year bar is the superior outcome. Now, I would have loved it to be the Chapter 7, which is more or less, yeah, we're going to sell everything you own and then portion it out to the people you owe money. Here's the thing. The house is already in foreclosure. They just postponed the auction of it. So the house is no longer an asset in this bankruptcy or in a Chapter 7 bankruptcy, if I understand it correctly. Only what other things they own. And the other things they own either cost a lot of money or is basically worthless. And it seems like their pension can't be... they can't... What do you call it? Their pension and social security seems to be protected. So they still, after all this, will make over $21,000 a month. It's extraordinary. The UST investigation raised serious and unresolved concerns about the accuracy of the debtors' sworn disclosures. They lied. However, in light of the debtor's current financial status, dismissals is preferable to conversion. The UST has reviewed 18 months of statement for 8 Bank of America accounts, and that review establishes that there is no meaningful pool of collectible, non-exempt assets for a Chapter 7 trustee to liquidate. Conversion would cause delay for creditors and administrative expense for the estate without the likelihood of any return to unsecured creditors. Basically meaning, if they go through a Chapter 7, it would cost more for the creditors to try to get the money than the amount they might get. So what they have left has no worth. The first concern regarding the debtors' sworn statements. Across 3 sets of schedules, the Chapter 13, the original filings in this case, and the amendments filed at docket 75 through 78, the debtors have sworn to statements that cannot all be true. Ownership of debtors' residence was sworn at 50%, then 100%, then 50% again. Unsecured debt was sworn at $511,327, then at effectively zero, then at $729,875. The debtors' animals were valued at $1,100 in both prior filings, described as seven retired horses and a dog, while the recent amendments valued the Quartet Farm LLC interest at $62,751 and values a single pony at $60,000. Debtors previously answered no to Schedule G, asking whether any leases were outstanding as of the petition date, but just recently disclosed a 12-month lease of the pony to a third party. Snipe Hunter. Oh, you're bad. You're bad. I have a feeling this response is going to leave a bad taste in the Owens' mouth. Good thing they are used to that. Oh, you're bad. Neither prior filing disclosed business income, yet the SOFA amendment reports gross income of $40,785 for 2024, $81,000 for 2025, and $26,000 for 2026. Neither prior filing disclosed GoFundMe income, yet the debtors have received more than $100,000 from GoFundMe donations. The amendments recently filed now disclose the receipt of $131,590 of GoFundMe funds in 2025 alone. So let's count. For the past 18 months, they had $378,000 in pension and social security. I believe it was over $132,000 in GoFundMe, puts us over $500,000, plus business income for roughly $60,000, putting them close to $600,000 income for the past 18 months up to, seriously? The amount they wasted in 18 months are more than most people have in total pension savings. And they just waste it. It is so... It's vile, is it? I mean, I represent people who doesn't have a nickel in retirement, in private retirement. Not a nickel. Not because they didn't try, but because they had lives. They're not in debt. They just didn't have enough to save. And here these fuckers, in 18 months, over $600,000, all gone. All gone. Item 13 of the SOFA asks for all gifts over $600 per person within 2 years before the petition date. Twice the debtor stated under oath that there were none, but the recent amendment now discloses $19,608 in gifts to daughter Laura Owens. And here is why I believe that number is absolute horseshit. Because if they had reached the threshold. I believe it is in Arizona, $20,000 in gifts. They had to report it to the IRS. So this here, I believe, is a completely made-up number, because the amount of money they poured over Laura Owens is substantially more. Previously, debtors swore twice that they had made no payment on a debt owed to anyone who was an insider within a year before the petition date, but the recent amendment now discloses $21,000 paid on behalf of debtor's daughter Sarah Owens in May 25, March 26, and May 26. Until the recent amendments, debtor Naylor's membership and manager interest in Godluck Shop LLC went undisclosed in both cases, even after the Arizona Department of Revenue raised it in their Chapter 13. The recent amendments also disclosed for the first time $7,000 in cashier's checks, Charles Schwab accounts, and over $10,000 of antique furniture. Folks, I did what can it be, a few months ago, we were on this channel, we were watching the raid on the Owens home, and we did some quick, very, very quick calculations of actual worth in furniture and other things in the Owens home, and I believe the combined worth of everything they had there, less than $8,000. What these antiques are, I don't know. I have no idea. Absolutely no idea. And a monthly horse insurance expense of $425 each appeared in one filing and vanished from the others. Statements of this character, if proven to have been made knowingly and fraudulent, would support an action to deny discharge under Code Section 727. The US does not abandon that view, but pursuing that remedy would not benefit the creditors that the US is bound to protect. Here's one thing I believe might be the result of this, but it's up to the bankruptcy court, because this amount of sworn statement under oath that are clearly false over and over and over again, as their daughter is facing 14 felony charges, including perjury. And folks, swearing under oath to something that is false is perjury. The state of Arizona have here another excellent way to make a statement. We do not accept this shit from these serial scammers. Will they do it? I don't know. But it would be fun. Conversion would yield no distribution. Code Section 1112b directs the court on a finding of a cause to convert or dismiss, quote, whichever is in the best interest of creditors and the estate. Conversion satisfies the standards only if a trustee would have something to administer. Here, a trustee would not. The debtor's residence is secured by liens exceeding $1.9 million against a value the debtors themselves placed between $1.5 and $1.576 million. With the first position areage above $191,000 that continues to accrue. There is no equity, and a trustee would likely abandon the residence under Code Section 554A. Yeah. So, they are going to sell the house. It's the only thing of value. The animals present no value for creditors for a different reason. Whatever the pony is worth, and the $60,000 figure is the debtor's own estimate, the state would have to take custody of a living animal and expend estate funds on shelter, food, and maintenance. The debtors' records reflect that those costs include boarding charges, feed and supply purchases, veterinary services, and association fees, aggregating $38,000 in horse and farm expense over 18 months. That is a fuck ton of money spent on one horse. Where I grew up, I mean, this. Welcome to Sweden, local famous people. There was a horse trainer named Olle Goop. Extremely successful. I mean, his horses have won millions, even in dollars, millions. And I grew up a few miles from his training stable, or so. And this world-renowned horse trainer, to get a horse now into his stable might cost around maybe $10,000 to $15,000 a year, maybe, for him to train one horse. Then he gets a cut out of winnings and all the things. And so for that one pony that they spent almost $40,000 over the span of 18 months, I think that would be. But then again, their records reflects this, but it seems insanely much. Transport from an estate with no cash would need a specialized broker to reach a narrow market, and would do so while the animal remains subject to a 12-month lease. The 7 remaining horses are described in every filing as retired, which is to say they have no market and cost money every day. I think, didn't Laura say they got rid of all the horses and only have one left? But here you have Jan Owens saying, nah, we have 8. The others are just retired. Custody and sale expenses payable ahead of unsecured creditors under Code Section 503 would likely meet or exceed any proceeds realized by the Chapter 7 trustee, who must close the estate as expeditiously as is compatible with the best interest of parties in interest. There are no other apparent non-exempt assets for a Chapter 7 trustee to administer. I would disagree, actually. They still have their podcast, which generates $50 a month, because now they only do reruns. Yeah, but it still has worth. You can force the Owens to sell. I mean, it's not a bad name of a podcast. It's not a bad idea for a podcast. Just sell it to somebody who's not a fucking scammer. I mean, it apparently still has an audience, even at $50 a month, doing reruns. At its height, what was the number? $80,000 in a year, or something like that. And that's amazing. Just put people in there who doesn't lie. Sell it to people who doesn't lie. That has worth. Remaining personal property is largely exempt under Arizona law and worth little net of the cost of collection and sales, and household goods held in storage secure roughly $26,000 in unpaid charges. The insider transfers described above are the only theoretical available assets as avoidable transactions, but realizing on them would require adversary proceedings under Code Section 547 and 548, funded by an estate with no unencumbered cash. Yeah. This is the clawback I've been talking about in previous streams. If they squandered away money to people, there is a way to claw back. But as the trustee here says, the trustee attorney says, it would cost more than it would probably get back. Moreover, the Chapter 7 trustee may eventually determine that the transferees are uncollectible. Collection from Laura Owens is already called into question by the fact that Laura Owens recently filed her own Chapter 7 filing in this court, which was ultimately dismissed. The GoFundMe funds are beyond recovery, and any remedy lies outside bankruptcy. The UST has particular concern about the GoFundMe proceeds. The debtors received approximately $132,480 in GoFundMe payouts into a single account, approximately $109,000 in January 2025. The campaign solicited the public by reference to debtors Owens' Parkinson's disease, history of cancer, and cardiac condition, and including the representation that his medical struggles has taken a toll both physically and financially. Over 18 months reviewed, healthcare and pharmacy disbursements from all 8 accounts totaled $17,000, roughly 2.7% of net spending. Okay, so she must have gone through all of that, because in the interview we heard last week or something, she could only find $243 that actually went to medical bills, but now it seems like she found more. While discretionary spending totaled $191,192. In the period during which the funds were deposited, $118,000 was disbursed, including $61,000 of mortgage payments, thousands of dollars of consumer credit card payments, $44,000 in capital contributions to debtors' limited liability companies. Oh, that is... So they used GoFundMe money to pour into their LLCs. I'm not that familiar with Arizona law, but I don't think that's legal. Transfers to their adult daughters, retail and online shopping, food delivery exceeding $1,200 per month. For fuck's sake. And they're just food delivery. On top of that, restaurants, subscriptions, and travel. Yeah, nobody's cooking in that home. Nobody is cooking a warm meal in that home. Those facts raise a serious question whether donors received what they were promised, but it is not a question that UST can answer here. The remedy available to the UST is an action under Code Section 727 to deny a discharge. That section protects the integrity of the bankruptcy process and preserves creditors' claims. It compensates no one. A judgment denying discharge would return not a single dollar to a donor, would create no fund, and would not adjudicate whether the representations on the fundraising page were true. The donors and GoFundMe Inc. are the parties withstanding to pursue whatever legal remedies exist as to the solicitation and application of donated funds in a forum outside of bankruptcy. That is the US trustee trying to tell the people who donated money to Owens to try to get their money back through. But again, there's no money. Their pensions are exempt for collection, I believe. Moreover, based on the UST's review of recent bank records, the GoFundMe funds have been fully expended and the accounts carry nominal balances. Yeah, But the GoFundMe is still open. Let's see here. Yeah, still open. And it's currently at $137,000. So since they filed for bankruptcy, they had another $5,000. There are people out there who are monthly or bi-weekly donors of like $50. It's insane. Therefore, record of any funds for the benefit of creditors by a Chapter 7 trustee would require multiple preference actions by an estate that lacks unencumbered assets to fund such lawsuits. The best interests of creditors and the estate favor dismissal. If the case is converted, creditors will be relegated to waiting to pursue their rights while likely standing to receive nothing from a Chapter 7 liquidation. A Chapter 7 trustee would be appointed, a new meeting of creditors convened, and the estate would remain open through investigation and abandonment. If the UST filed a complaint objecting to discharge, the deadline would run 60 days after the first date set for meeting of creditors under Federal Rule of Bankruptcy Procedure 4004A. A contested Code Section 727 action would then require discovery, depositions, motion practice, and trial. At least a year would pass between conversion and judgment. Pension is exempt. To my understanding, the way Ron has set up, because the majority of the pension is Ron's, the way it is set up makes it uncollectible. And yeah, for $21,000 a month, and I've said this before, they could rent an absolutely amazing condo for $5,000 a month, then splash out $5,000 a month on food and stuff, and still be able to pay back $10,000 a month to the people they owe money. But they won't. They won't. In response to a Code Section 727 action, the debtors would likely attribute false statements to prior counsel and to debtor Owens' documented illness, and would likely argue that the amendment's evidence is an intent to correct rather than conceal. The US believes those defenses would fail, but cannot represent that success is assured, and in any event, success would still yield no distribution to creditors. A Code Section 727 judgment would leave creditors holding exactly what dismissal gives them now. Claims enforceable under state law only a year later. Under dismissal, creditors act immediately. The secured lender may notice and complete its trustee's sale. Unsecured creditors may file or resume state court actions, including the 2 pending actions by JP Morgan Chase Bank, to reduce claims to judgment, record judgment liens, and garnish non-exempt assets. No trustee stands between them and their remedies. The 2-year bar assures that those remedies cannot be interrupted again by a third bankruptcy petition filed on the eve of a sale. The comparison is therefore between a certain and immediate benefit to every creditor and a contingent one, available to no one for at least a year, that would cost the estate money to pursue and would dispute nothing even if it succeeded. Creditors are better served by remedies they may exercise today than by the prospect of a judgment that is neither assured nor remunerative. And here we go. Cause exists for dismiss for bad faith, which also supports the 2-year ban. Yeah, remember, they opposed the trustees' suggestion of a 1-year ban. A month later, or a month and a half later, She says, no, 2 years ban from every federal court. So they can't move out of state and file for bankruptcy in another state if the court goes on Miss Jaimo's line. Cause exists independent of the debtor's own request for dismissal, and that same cause supports the 2-year bar to refiling. Code section 349A provides that the dismissal of a case does not prejudice the debtor with regard to subsequent filing, unless the court for cause orders otherwise. The phrase, unless the court for cause orders otherwise, authorizes the bankruptcy court to dismiss the case with prejudice. Bad faith is cause for dismissal with prejudice. The UST addressed each of the factors required to find bad faith in a stay objection, docket 37. Those same factors constitute cause for dismissal with prejudice. Specifically, 1. The debtors made numerous misrepresentations in their pleadings in this case and in the Chapter 13. 2. The history of the debtors' filings and prior dismissal show a complete disregard of their basic obligation as bankruptcy debtors, including failing to file and produce tax returns and failing to cure substantial planned payment arrears. Hey, Malin, do I think the DOJ will still investigate after the dismissal? It's a long shot. You never know. You never know. And I mean, Ron is over 80. And Jan also disclosed that there is a life insurance on Ron. And Ron is old, he is ill. Unironically and cynically, both Jan and Laura are waiting for Ron to die so they can get probably millions from the life insurance. Now, are there life insurance money things the creditors can go after? I don't know. That is way above my pay grade. I need to ask an actual Arizona bankruptcy attorney, and I don't know any. But if you know somebody who practice bankruptcy out of Arizona, ask that person if they would be interested in talking to me. Where were we? The history of the debtors' filings and prior dismissal show a complete disregard of their basic obligation as bankruptcy debtors, including failing to file. Oh, we already said that. 3. The sole purpose of this bankruptcy filing was to halt an imminent sale. And 4. The debtors demonstrated egregious behavior, including failing to appear at a scheduled initial debtor interview, in this case, and failing to produce to the UST standard documents required of all Chapter 11 debtors until ordered by the court to do so. In the recent case, Corbin, the court confirmed that the bankruptcy court has authority to dismiss a bad faith case with prejudice. In considering whether dismissal with prejudice is permissible, the Corbin court cited the Second Circuit Court of Appeals decision in the Cass case, which held that the bankruptcy code authorizes bankruptcy court to dismiss bankruptcies filed in bad faith with prejudice, that is, with a bar on future filings beyond the 180-day period contemplated by Code 109G. And they quote that. A dismissal with prejudice cannot be avoided simply because the debtors themselves seek voluntary dismissal. The Corbin court addressed and rejected precisely that argument, holding that, quote, while the debtors does have an unfettered right to dismiss her bankruptcy, she does not have the right to evade the consequences of her bad faith filing. In this case, a 2-year bar to refiling is reasonable and proportionate. The debtors had filed 2 petitions in 10 months. Each filing interrupted a creditor remedy, and the second filing followed a dismissal based on deficiencies that the debtors made no effort to cure. A shorter bar would expire before a trustee's sale could realistically be completed, and would invite the third filing that Code Section 362C3 was enacted to discourage. 2 years is long enough for creditors to complete their remedies without interruption, and not so long as to foreclose relief should a genuine need later arise. Debtors' agreement to dismissal with 2-year bar to filing. Counsel for the UST has conferred with debtors regarding the relief requested herein, i.e. dismissal with a 2-year bar to refiling. Debtors stated that they will agree to that relief, but dispute any factual assertions in the UST supplemental response. Yeah, the 2-year ban is okay, just as long as we don't have to admit that we are lying scammers who lie. Sure. Wherefore, the UST respectfully request that the court dismiss this Chapter 11 case with prejudice to the filing of any bankruptcy petition by either debtor for 2 years from entry, and grant such other relief as is just and proper. Respectfully submitted this 3rd day of August, which is yesterday. Eileen J. Lashinsky and Jennifer A. Giaimo. And certificate of service to Anne and Ron. Yeah. Now the court will convene on Thursday. It will probably take a few days for them to make their ruling official. But I would be absolutely surprised if they don't go with, dismissed with prejudice and a 2-year ban. What will be interesting is if the court adds, and we will refer this to the district attorney to investigate possible crimes. That would be amazing. It's a long shot, but that would be absolutely amazing. Folks, when it comes to the Jan Owens alleged serial scamming, it's about to end. And will probably restart as soon as Ron dies. But at least it's about to end. Which leaves us with Laura Owens and her upcoming trial. Now, it has been postponed a bit because there may or may not be a new offer of a plea. I don't think Laura wants to plea. The only thing she wants is to postpone, because she's still abusing Mike Maraccini in California. She is trying to appeal the decision to dismiss her absolutely fraudulent restraining order against Mike. Because the moment she goes to trial, the moment she admits guilt, the moment a jury finds her guilty, is the moment she will lose all credibility against her claims against Mike Maraccini, Greg Gillespie, and Clayton Eckert. Oh, this is Malin. She writes in Swedish. It's about to happen. Does he like it? Yes, he does. Hold on here. Let me show you. Where is it? I have it. Dun, dun, dun. Dun, dun, dun. Let me show you. Where is it? There. Look at him in the background there. Look at him. Shh. see. Sorry. Mr. Jingles likes his strawberry hut. Told you. And you can maybe barely hear him snore. Now he's off again. So yeah, I bought Mr. Jingles something he likes. Yay! This is one of 3 trees. This is the only one he uses. I have those scratching poles, a number of those. And I try to protect my the stairs. You mean the what do you call it? The balusters, ballista, with those wraparound scratch. He doesn't give a shit. I have, these feathers. That's like which you can bounce around. Maybe 30 seconds, and then he doesn't give a crap. But this one, yay! This one he likes. Folks, thank you. Thank you so much. Onwards towards the next adventures, which will be... There's a lot of filings around in cases that I cover. Because I had one trial and one backup trial. The one trial I was going to cover was the Courtney Clinic trial. Fucker took a plea deal. And the other trial, the Sarah Grace Patrick trial, postponed. So I don't have a trial at the moment. So in search of a new trial, I will find fun things to cover roughly at the same time. I believe 1:30. After lunch or at lunchtime, depending on where in the States you are. But yeah, I will find fun stuff for you to watch. So keep a lookout for a stream from yours truly at around lunch, 1 p.m., 1:30. And I will see you in that stream or on that video. Thank you again. See ya. Bye-bye.
Santa Claus, riding in with the winter laws. Santa Claus, streaming live for the roaring masses. Ho, 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 raise them horns, old Judge King in a crown of thorns. Santa Claus, streaming live for the roaring masses.
Hold on. Oh, I did not see this. Okay, folks, let me show you this. Here, first, thank you to TST, Starbucks money, $20. Parabellum sent memberships and is a member. And I missed this one to Victor Man. Thank you so much for your $5. I don't think state can charge because bankruptcy is federal. Yeah. Then, yeah, fuck. Oh, yeah. But it might be a federal perjury case. Who knows? We can always hope. Okay, now I'm done. Get out of here. Bye-bye.
Santa Claus, riding in with the winter laws. Santa Claus, streaming